$5 for a law student. It comes with some other good benefits, magazines, as well as a subscription to the Harvard Public Policy Journal, which is fun to read or carry around. It looks smart. That being said, I'm going to turn the time over to our president, Gina, and she'll introduce the speakers.
Hi everyone, I'm Jeannie Huber. I'm this year's president. I want to thank you all so much for coming. I really do appreciate it. Please give a warm welcome as well to Josh Blackman, who is visiting us from South Texas College of Law. Many of you, I'm sure, do know Vladeck already, and he's a professor here as well. Both are experts, among many other things, on constitutional law, so this should be a very interesting debate, to say the least. So I'll turn over to Professor Blackman. Thank you so much.
Okay, hi everyone. How's everyone doing? Well, can you hear me? Perfect. So I first of all would like to thank the Federalist Society and my good friend Steve Vladeck. We've done this now 3 years in a row. We did Obamacare. Last year we did the ISIS. And this year we're doing immigration, so we're totally rounding out the entire separation of power sphere.
What's the score, by the way?
Oh, we're not keeping score. This one's a tiebreaker, maybe. No, I don't know. So our discussion today focuses on immigration. And I want to preface my remarks by agreeing with Steve that our immigration system is quite broken. In fact, I'm in the somewhat odd position that I am opposing policies on constitutional grounds that I agree with on policy grounds. I, in fact, support the president's immigration agenda. And in briefs I've submitted to the court, I've said as much that I support them. So I agree with what he wants to do, but I do not agree they can do this without congressional authorization. So let me begin. There are two major policies we'll be discussing today that the president instituted. The first is called DACA with a C, which stands for Deferred Action for Childhood Arrival. These are the so-called dreamers. Does this mic not work?
Sounds pretty.
The second policy is called DAPA, Deferred Action for Parents of Americans, okay? This is a policy affecting basically parents of American citizens. So how do these policies emerge? We've had a number of attempts at reforming immigration law that have simply failed in this country. Okay, so back in 2010 and 2011, the president tried to enact a law called the DREAM Act, which again, I support as a matter of policy. And this law will provide a pathway to citizenship for certain minors who came here illegally, below a certain age, who have obtained a high school degree or a college diploma, and who are generally good people. Okay, this sounds like a good policy, but the bill was defeated in Congress. Okay, fine. Several months after the bill was defeated in Congress, the president announced the policy became known as DACA. So how did this policy work? It relies on something called deferred action. What is deferred action? It is not amnesty. I want to make it very clear. People say this is executive amnesty. That is a misnomer. It is not granting citizenship to people. All the policy does is it says, we will temporarily suspend your deportation, right? It could be turned on any time, but we will temporarily suspend it. With that suspension comes a host of benefits, one of which is work authorization. So usually people here illegally cannot work. With this deferred action status, these people are now given work authorization to earn income and do everything else that people can work. Okay, this affected maybe 1 to 2 million so-called dreamers, and the exact number isn't exactly certain. The second attempt at a reforming immigration law took place in 2014, shortly before the midterm elections. This was what was called bipartisan immigration reform, the big kahuna. How do we deal with the, what the number is, 15 million, whatever the number is, people who are here undocumented, right? How do we deal with them? This bill would have provided a pathway to citizenship for the overwhelming majority of these people. Okay, again, I would support a bill like this, and I was sad that it was defeated. So what happened after it was defeated? The president, the day the bill never even came up for a vote, okay, the day the House said we won't even vote on it, the president gave a press conference at the Rose Garden where he basically said, if Congress won't fix immigration law, then I will. I will use whatever power is at my disposal to affect a change in immigration law. He spent the entire summer planning about it, and about 2 weeks after the election, on November 19th or 20th of 2014, the president announced in a speech that there will be a new policy called DAPA, and what it stands for has been debated, but it's effectively Deferred Action for Parents of Americans. So if you are a parent of an American citizen, or a parent of what's called an LPR, a lawful permanent resident, you can now request this deferred action status. And with this, your deportation will be suspended for some period of time to be determined. As well, this suspension will entail the benefit of work authorization. So now these people, the parents of the citizens, will be allowed to engage in lawful employment in their wherever they happen to live. Okay. Shortly after DAPA was announced, several lawsuits were filed. I'll focus almost exclusively on one of them. The first lawsuit was filed by the state of Texas on behalf of about 25 other states. Texas, and I don't want to talk about standing today. Steve may want to, but I'm going to avoid standing for them. No standing. So Texas asserted in its claim a couple things. Texas claimed that first,
Although Texas doesn't have standing.
which we're not going to talk about. So first, Texas asserted that the administration failed to comply with the APA, the Administrative Procedures Act, which basically says you need to have notice and comment for certain substantive important rules. Indeed, this policy was announced by an executive memoranda. There was no notice and comment. We're not going to talk about that either, but Steve, did it comply with APA?
Do prosecutorial decisions always have to comply with the APA?
Thank you. That's a yes. But the second claim, I told you this will be fun. The second claim that Texas raised, what we will be talking about today, which is the constitutional claim. So, and again, in full disclosure, I filed an amicus brief on behalf of Cato in support of Texas, both in the district court and the circuit court, and I will file one in the Supreme Court. So I'm going to go all the way in this one, 3 for 3. The briefs get better, I promise, at each stage. So Texas argued in its complaint that the president has violated the separation of powers. Indeed, they said that the president violated the constitutional clause known as the Take Care Clause, which many of you probably have never even heard of before. I hope you have. But the Constitution says the president shall, quote, take care that the laws are faithfully executed, right? What does it mean to faithfully execute the laws? This is not a clause that's been given much attention by the Supreme Court, but this is a clause that's directly implicated in this case. So that is the general sketch of the facts. Steve, is that a good, fair sketch? Sure. Okay. So now that we've had the background set out, I'd like to take a moment to explain why I think the president has not complied with this duty under the Take Care Clause. So the word which my good friend Steve will repeat over and over here, he said it once, is discretion. Discretion. And I don't quibble with this. Indeed, in virtually every statute that Congress passes, they vest the executive branch with discretion, okay? The executive branch doesn't say, Congress doesn't say you must deport this person, you must deport this person.
Sometimes Congress does.
Well, they tried with Chadha, and that was a little, anyway.
The INA has provisions dealing with the mandatory detention of certain non-citizens who fall into particular groups.
Well, groups, yes, but they often vest the executive branch with discretion of how to go about engaging in their job. And I don't quibble with the fact that these agencies have discretion. The question is, what is the scope of this discretion? And to start this analysis, I want to actually look at the Obama DOJ memo. The Office of Legal Counsel wrote a memorandum explaining, oh, he's got it printed out highlighted with beautiful yellow highlighter, explaining why they think that this policy is constitutional. And I will read from it and see if can verify if I'm quoting accurately. But what the memo said is that, what has to happen is that an agency's enforcement decision should be, quote, consonant with, rather than contrary to, the congressional policy underlying the statute. So we have here is there's not a clear delegation of authority, and OLC recognizes this, right? It's not clear that the president can use deferred action to suspend the deportations of 4 million people, give or take. OLC recognizes. They said congressional policy is consonant or consistent with our policy here. Where I argue or I differ from OLC is not in the framework, but on the facts. And a careful study of immigration law reveals that this indeed is not consonant, that this policy is qualitatively and quantitatively different than previous instances of deferred action. And so what is the constitutional hook here? So the Supreme Court has said in a case many years ago called Heckler versus Cheney, which Steve probably has a copy printed out also. Thank you. So there was a footnote in Heckler v. Cheney, which Steve and I will be no doubt talking about soon. But what the Supreme Court basically said, if an, quote, agency has consciously and expressly adopted a general policy that is so extreme as to amount an abdication of its statutory responsibilities, that object is subject to judicial review. There was a second case by the DC Circuit about 1994 called Crawley Caribbean Transport versus Pena. You hear that one?
No.
I wouldn't find it. And what the court said there is when there's a broad policy against enforcement, this poses special risks that the agency has consciously and expressly adopted a policy that amounts to an abdication. So we have this framework here, right? This is not Josh making stuff up, although Steve will probably chart that in a moment. There is a framework here of when agencies try to use a policy of non-enforcement, and that amounts to an abdication of law, that would be something that the courts can review. Okay? So the case I'm making here is that the facts of DAPA fit into this framework, that there's really not a precedent of Congress authorizing the scope of this discretion. And I really don't want to dwell too deeply into the nuances of immigration law, but I'll explain to you, and you can read my articles if you want to back it up, that generally speaking, when Congress, he's got it also. This is yeah, part one. And those are double-sided too.
Wait.
Yep.
Part two.
Part two, yeah. So I have two parts of articles which you can read about later. But the first part of the argument goes like this. Historically, when the president engaged in deferred action, it was done with the consent of Congress such that a bridge was formed. Okay, what do I mean that a bridge was formed? I'll give you an easy example. So during Hurricane Katrina, there were a lot of foreign students attending schools in the Gulf Coast. The second the hurricane hit, their schools were shut down. If you are a foreign student and you're not enrolled in a certain credit load, your visa goes away and you'd have to leave the country immediately. So as a temporary measure, President Bush said, I'll tell you what, I'll give you till next semester to enroll at another university. And if you're able to enroll in another university, I won't deport you these 3 months, okay? That is an example of deferred action where a deportation was temporarily suspended as a bridge from a lawful status before Katrina to another lawful status after Katrina. And if you look at the history of what Congress has done, this is how deferred action has been used with the president. What we have here is not a temporary stopgap measure where there's a bridge from one staff to the other. The 4 million people who are given deferred action under DAPA, these people have no prospect of citizenship, specifically because Congress has not appropriated it. Generally speaking, if you are the parent of a US citizen, you have to wait till that child is 21 to first petition for your citizenship. This is not like waiting a few months until after the hurricane is settled to enroll in the university. This is done as a quasi-permanent measure. Indeed, it's at a 99% renewal rate. Very few people have had it canceled with the additional benefits of a work authorization, which is trying to effectively create a workaround. Congress denied the president the authority to give these people certain benefits. The president used authority that he really did not have to provide it. And this is the basic frame of why the statutory authorization is not consonant with the president's actions. Okay? I'm going to stop here and let Steve tear me a new one, as I'm sure he will. I can see him, he's taking lots of notes. But that is the general frame, and we will go back and forth. So, Steve?
Great. Thank you, Josh. Thanks to all of you for coming. I realize it's probably more for the Chipotle than, it's probably Chipotle, then Josh, then me, but I'll take third. So let me start with a fact that I think will help to illuminate this whole conversation. According to the Department of Homeland Security, there are somewhere between 11 and 12 million individuals in the United States who are legally subject to deportation, right? So who are in various different kinds of status or non-status situations where the US government could, if it wanted to, legally pursue deportation proceedings against them. It's a big number, right? It's part of why this is such, I think, a lightning rod politically. The Department of Homeland Security also says that at most, it can probably deport somewhere between 300 and 400,000 of those 11 million on an annual basis. And that's if everything goes right. Right? That's if there's not that much judicial review. That's if there are no procedural hiccups. That's if, Metro's running. Well, no, that's just everything else. The reason why I start with those numbers is because what this whole conversation is really about and I think what Josh importantly downplayed in his opening remarks, is prioritization. Right, that is if you are the Secretary of Homeland Security and you're told that we've got a pool of 11 to 12 million people who we can go after, but you can only actually successfully deal with about 350 to 400,000 of them, who are you going to prioritize, right? Which cases are you going to highlight? And is the Secretary entitled to make those kinds of choices? Right, that's the real question here. And so one of the things that came along with the announcement of the DAPA program was a very comprehensive memorandum from Secretary of Homeland Security Jay Johnson about prioritization preferences, about how this administration is going to choose. And not surprisingly, some of the things that it prefers to prioritize involves whether the individuals in question are felons, whether they've been convicted of other crimes, whether they've been involved in tortious conduct, whether there are other ways in which they have not been contributing to society. The kinds of things that I actually suspect if we all sat in a room, we would hammer out as reasonable priorities. Priorities that no one suggests are inconsistent with the various statutory commands Congress has provided. So I just want to frame this whole conversation as there's a numbers problem here. And so isn't it actually entirely understandable that the executive branch would say, let's focus on the cases of the folks who we think pose the most danger or the least value to the society around them, and we'll focus on deporting them. So let's start there. Okay. Point number two. So Josh's principal argument that President Obama is violating the Take Care Clause of Article 2 turns, I think I can say entirely, on the conclusion that there's no congressional authorization for what he's doing. Is that fair?
Not consonant with, I'll say that. There is authorization for prioritization, which I don't discuss, but the manner which is going about it is not consistent with congressional policy.
Good. Okay, so let's start there. So congressional policy. Congress has repeatedly recognized the validity and the legality of deferred action programs in general. Do you agree with that?
Yes.
Okay. How do we know this? Well, so those of you who have a real ID, do you guys have a real ID? Right? In the Real ID Act of 2005, Congress specifically defined as evidence of lawful status, among other things, proof of citizenship, proof of lawful permanent or temporary residence, or, quote, approved deferred action status, unquote, right? So Congress has, for decades, recognized that there is this thing called deferred action and recognized the authority of the executive branch to decide which categories of individuals ought to be deferred. Now, it's true, as Josh says, that the deferred action programs we've seen in the past are different in both degree and kind from DAPA. That, I think, is an inescapable fact. The question is whether that by itself means Congress hasn't authorized them. So let me turn to that. So Josh talked about the benefits of deferred action as one of the ways in which this program is different from previous ones. Well, of course, the principal benefit of deferred action is not being deported. And in that regard, this program is no different from prior deferred action programs. And work authorization, right? All prior deferred action programs have also brought with them work authorization. This seems to be one of the real planks. People say, well, how can you be, violating Congress's intent by authorizing all of these individuals, 4 million perhaps, to work? Well, let's talk about Congress's intent. So I know you guys have read and memorized 8 U.S.C. section 1324 AH3. Professor Frost? Totally. And this is from the IRCA, the Immigration Reform and Control Act of 1986. So a 29-year-old statute that defines unauthorized alien as someone who is not, which defines an unauthorized alien not entitled to work in the United States as an alien who is neither an LPR nor, quote, authorized to be employed by Congress or by the Attorney General, or now the Secretary of Homeland Security. Right, so the statute specifically says the executive branch can authorize immigrants to work who otherwise weren't entitled to, right? And there's no statutory prohibition on doing so. So again, there's nothing new in the work authorization, right? What's new is the scale and scope of the program, not the benefits, not the purpose, not the intent. All right, so let's turn last to the scale and scope of the program, because that is really all this boils down to. Is DAPA just so much bigger than prior deferred action programs that there's no way we could think Congress had ever contemplated given the executive branch this kind of enforcement discretion? Well, Josh mentioned the famous footnote from Heckler versus Cheney. I'm actually going to quote it because I think it's worth reading. This is footnote 4, not that footnote 4, from the Supreme Court's 1985 opinion in Heckler versus Cheney. And the court says, we do not have in this case a refusal by the agency to institute proceedings based solely on the belief that it lacks jurisdiction. So too here. Nor do we have a situation where it could justifiably be found that the agency has, quote, consciously and expressly adopted a general policy, unquote, that is so extreme as to amount to an abdication of its statutory responsibilities. And that's the question, right? Is expanding deferred action to a larger group of individuals for reasons that are tied to a combination of familial unity and prioritizing enforcement discretion to go after those folks who are of the least value to the United States, so extreme that it is an abdication of the Secretary of Homeland Security's statutory responsibilities. In other words, right, Josh is effectively trying to equate novelty and scope with extremity on the theory that extreme refers to size. And what I would suggest is extreme actually refers to departure from what the agency is supposed to do in the first place. So let me give you a contrast. If Rand Paul wins the Republican primary and presidential election and comes to office and says on the first day, I will no longer enforce the tax code, right, period. Well, that could be defended as an exercise of enforcement discretion, and I dare say that would be so extreme as to constitute the IRS abdicating its statutory responsibilities.
I agree.
To collect taxes.
I agree.
Okay. I don't think the immigration authorities of the US government choosing to prioritize one group of immigrants over the other and having substantive reasons that sound in, among other things, keeping families together, rewarding good behavior, and otherwise promoting national priorities is an extreme departure from the authority vested in these agencies by the INA. If anything, I think they're deeply consistent with them. But don't ask me, ask Congress, which keeps funding everything that the Department of Homeland Security is doing.
Thank you. So I think Steve, as he always does, makes a very sharp point. His discussion was on prioritization. And the reason why I downplay prioritization is because I'm not contesting the prioritization. If DHS wanted to prioritize deportation of felons over families, to use the bumper sticker, that's quite all right, and I don't have any problem with it. But what this policy does is different. It's a prospective licensing of millions of people. It's announcing in advance that if you register for this program, we will not deport you. We will not. And I think this runs headstrong into what congressional policy is. Congressional policy made it very clear that the parents of US citizens, I won't use a phrase that's been in the vernacular, Donald Trump and others have used it, but these people are not priorities under the immigration law of getting these sorts of benefits. This law prospectively licenses their presence, and then affords them the benefits to stay here and keep working and doing everything else.
But can I pause a second? Is prioritization about priorities for benefits, or is it about priorities for removal?
Priorities for not enforcing the immigration laws against them.
Right, and so, but prioritization is not framed as being about, should we prioritize these people? It's about, should we prioritize other people and leave these people alone?
It's about whether you're prospectively licensing to saying we're not going to subject you to the law. It's very much the case that these people are being exempted from the naturalization power. So it's not just a matter of size and scope. It's not just saying that we're not going to enforce the tax code. It's actually saying to millions of people, we will not enforce immigration laws against you. And oh, by the way, if you register, we will give you these benefits. Indeed, there was actually a colloquy in the district court proceedings in Texas where what happened was the court said, why don't you just start prioritizing now? Why do you need to also afford the benefit of statutory authorization? And the government said this. They said, we need to offer the work authorization as an incentive to get people to sign up, right? So effectively, they need all these other elements of effectively legalizing a person's presence for years at a time, right? As a way to get around the fact that Congress denied them this sort of authorization.
So let's just be clear. Nothing in DAPA is legalizing presence, right? I mean, that's also a bumper sticker from the other side, right? What DAPA is basically a promise. And the promise is, listen, so long as you don't screw up, right, we're going to leave you alone and we're going to let you get a job. That's all it is. It is not legalizing. They do not all of a sudden have legal status in the United States. And it's worth stressing that this is actually such a temporary, small stopgap measure. But I want to go back to the
A
basic point.
stopgap to what, though? A stopgap to what? That's exactly the point. The president's made clear that the people given these benefits are basically untouchable for the future.
That's not true. Hold on a second. That is just not true.
He said
That is just not true. If someone who is registered under DAPA goes out and commits a felony, right, they are not untouchable under the immigration
Do you know what the
laws.
renewal rate has been for DACA? Like 99.9%. Virtually no one has been
And
taken
how many
off of it.
examples do you have of DACA registries who have committed felonies but been renewed?
Those are probably the very few that we know.
Do you have any
of.
examples of that?
The better question is how many examples have there been of people denied DACA, right, for reasons that are not felonies? Virtually every single person who applied for DACA was given it. Virtually every single one. This has not been the exercise of
So what
discretion.
you're saying is that popular commentary overstates the number of non-citizens who don't have status who commit violations of our laws and who therefore would otherwise be ineligible for DACA?
I don't understand your question.
I mean, you read into that this is a rubber stamp. I read into that maybe most of these people are actually living perfectly lawfully and are subject to DACA under the relevant criteria.
If this was in fact a temporary stopgap measure, right, we would see people perhaps not getting it renewed automatically. What we actually have is a situation where people who get it are meant to have it for the duration of this administration and hopefully beyond, right? This is not meant to be a temporary measure between one hurricane and another. I think that is, sorry, between the hurricane and afterwards. I think that is not just a departure in size and scope, but also in the nature of how this is being used. We have to be very clear about the history of these bills, which I do think is relevant. We look at cases like Youngstown and others. We look at what the antecedent legislative history was. The president specifically asked the sort of authority he would want to exercise, and Congress said no. Here he's trying to use it in many ways. In fact, DACA and DAPA rose from the ashes, like the phoenix, of the defeat of the DREAM Act and bipartisan.
All right, but you're kind of skipping over all the other things that the DREAM Act would have done that the president knows he cannot do by executive order.
Mm-hmm.
Right? I mean, so Josh would have you believe that once the president lost the DREAM Act, he just rewrote it as an executive order and promulgated it. No, right? The DREAM Act had all kinds of legalization routes. The DREAM Act had amnesties built into it. The DREAM Act had lots of substantive provisions that everyone agrees only Congress could provide. So yes, in the face of the Senate's completely preposterous refusal to let the DREAM Act be voted on the floor, even though it had a majority of support, President Obama said, well, let me see what I can do within my constitutional authority. What I can do is I can defer the removal of individuals who meet certain criteria that I established, and I can authorize them to work for the duration of their deferred removal. That's not only consistent with historical practice, it has clear support in pre-existing statutory authorization, and that was not why folks were opposed to the DREAM Act. Right? Josh's basic argument is that the only problem with DAPA is that it's much bigger and potentially much longer than prior examples of deferred action. That's a policy objection, not a constitutional.
But the take care clause specifically says the president shall take care of the laws are faithfully executed. And
So which law is not being faithfully executed?
The INA. Indeed.
Which part? The part that refers to deferred action? The part that gives the
phrase deferred action is actually not in the INA. It's a policy that's been recognized in subsequent statutes, right? The 1967 INA doesn't use the phrase, okay, it's so quick, right? The 1965 INA doesn't use the word deferred action. It's been recognized and reflected in
50 years ago, Congress did not authorize deferred action.
But what is not consistent here is how the president has been using. So if I could go back to the take care clause, there's a little constitutional history. There are some reflections on this in the founding of our country. So in the earlier drafts of our take care clause, right, the framers had it as a the president shall dutifully take care of the laws, right? And the phrase duty implies an obligation, a commitment. And this was actually changed by the Committee on Style, including James Madison, Alexander Hamilton, among others, to faithfully. And the idea of faith is one we've had in contracts and others going back for millennia, the idea of good faith. And you actually have to imply that you're trying to work within the confines of what you're given. And there's agency principles there as well. For 2 years leading up to DAPA, the president consistently said, I do not have the power to do this. I do not have the power to do this. The power to grant deferred action to the parents of U.S. citizens. There were very specific calls for him to do this. He said he could not do this. And indeed, the president found limits. People wanted him to grant deferred action to the parents of the dreamers. In other words, the parents of the dreamers. And the president said, I cannot do this because this goes too far. There's a bridge too far. So indeed, there is a limit of what can be done. And we obviously disagree about the scope of the limit. Where we disagree, though, is to what extent does the statutory authorization authorize the president to grant these sorts of treatments?
So, I mean, I'm glad you brought up the parents of the dreamers. So let's be clear, right? DAPA is about parents of individuals who have lawful status, right? Parents of U.S. citizens or parents of individuals who have green cards. The dreamers, right, are not they. And so parents of dreamers are in a different category, right? They're not one generation removed from lawful status. They're actually 2 generations removed, or they're more than 1 step removed from lawful status. Right? And the president concluded, and the OLC concluded, that in fact it wouldn't be consistent with the INA and with the various authorities Congress has provided to defer action on behalf of those individuals, because in that case there was no similar connection to the overarching goals of the INA. Josh reads into that proof that DAPA itself is problematic. I read into that proof that the executive branch has a deeply principled position on exactly what the president is and is not allowed to do under the INA. And oh, by the way, that's exactly what footnote 4 of Heckler versus Cheney requires.
So the reason why I read into that action, the fact that parents of the dreamers, is that Congress and the INA does have a clear policy of not affording benefits to the parents of U.S. citizens. This one is very clear. So there's actually a colloquy between, I think it was Senator Robert Kennedy back in the 60s when this law was being debated. And someone basically said, but what happens if an alien comes here and gives birth to a child, right? Could that child then petition for citizenship for the parent? And the members of Congress say, of course not, that's absurd, right? This is a contemporary debate we have today. So they basically put in a cap saying that US citizens who are born here have to wait till they're 21 years to then petition for a green card for their parents, okay? This is a very clear policy. And the exact group that DAPA is benefiting, the parents of US citizens, are those immigrants that Congress disfavored. And I think you can't get past that when you're trying to say what congressional policy is.
So let's be clear, right? There are scales of Congress disfavoring immigrants. I really don't think that the parents of dreamers are disfavored to the same degree as aggravated felons. And so I think we should probably, be careful about our words here, right? It is certainly true, as Josh rightly says, that Congress has historically chosen not to confer benefits on parents of dreamers or equivalent populations. But let's again be clear, right? DAPA is not conferring benefits upon those people. DAPA is deferring deportation.
That's one hell of a benefit.
It's not a benefit.
Yes, it is.
It's an exercise of enforcement discretion.
Well, for the people who are not getting removed, they're getting something they really like.
So without DAPA, were they going to be removed?
There's a chance they could have been. They would have modified their conduct in accordance with. One of the things that DAPA does is eliminates the threat and incentive enforcement. People say, maybe if I'll be removed, maybe I should voluntarily self-deport.
So there was this lovely debate a couple of years ago, right, about whether a state could basically set removal priorities for the federal government. And how'd that work out?
Arizona, you're talking about?
Yeah.
And they lost.
Right. And the Supreme Court, in an opinion by Justice Kennedy, made clear that the absolute discretion to set removal priorities to decide whether alien 1 should be removed versus alien 2 rests by statute with the executive branch.
And so on a case-by-case basis, so Justice Kennedy wrote, on a case-by-case basis, this amounts to a broad policy that rubber stamps virtually everyone who applies within this specific category.
But guys, I mean, just so you're clear on what you're hearing, Josh is telling you that deferring deportation is the same thing as conferring citizenship.
I didn't say that. Oh, I did not.
You equated those benefits.
No, I didn't. I didn't say citizenship. I never used that word.
Your proof that Congress...
The C word? I didn't use the C word.
Your proof that Congress... So, I'm sorry, I must be old. I thought about 4 minutes ago you said that the proof that Congress disfavors this particular class of immigrants is the fact that they were benefits for like citizenship.
Yes, in the context of children applying for a green card for their parents.
Right, and what I'm trying to say is the fact that Congress did not open a path to citizenship is not the same thing as Congress stating you must therefore deport all of these people the second you find them. And
I never said that.
But then why can't the executive branch decide what order they're going to deport?
Because one of the aspects of deportation is the threat of deportation. Like any crime, right? We know if I go and jaywalk, I'm probably not going to get a ticket. But the threat exists, and maybe I'll modify my conduct in accordance with. By prospectively licensing this, you are limiting the threat of deportation for people who are here. And that nullifies one Congress's purpose of having it. Of course, Congress only appropriates money for 400,000 deportations, but other people know they have the threat of doing so.
So I think we're going in circles, and this is probably getting past the point where
almost Q&A time.
Let me just make one quick observation about this whole sort of notion of Congress and the threat. if you receive DAPA, right, if you are certified under DAPA, there are any number of acts or behaviors that if you engage in them, your certification will be revoked, right? And so if Josh is worried about deterring conduct that might potentially put you on the radar of the immigration authorities, there is nothing to the argument that people who receive DAPA certification will somehow be less deterred. If anything, the fact that they have registered with the government makes it that much more likely that the government will be well aware of their conduct than individuals who are in the country out of status with no grid connection whatsoever, right? So at the end of the day, if the argument is about deterrence, color me as someone who thinks that someone who goes to the government voluntarily is going to be a heck of a lot more deterred from risking that status than someone who lives off the grid.
Okay, I'll let Steve get the last word because he's taller, and I will open up for Q&A. I'd love to hear your questions, but I appreciate it very much. Thank you so much.
Or comments in the form of questions.
With a question mark at the end, an inflection is always appreciated.
I'm Ron Burgundy.
Exactly. All right, who wants to go first?
I would actually just love to hear your response. I was going to essentially ask the question that Professor Vladeck just raised in terms of like, why do you think that there is a greater chance of deterrence if there's not this benefit?
Right. So again, DACA has had basically 99% renewal rate. So short of committing a felony, which is never a good idea, and if you commit a felony, generally you're arrested and you're connected to the grid, right? Once you're arrested for a felony, you are in the grid. It's irrelevant if you register. They've had a 99% renewal rate. So it's been effectively a rubber stamp. And short of committing a felony, you're going to get it renewed. And I think the purpose of DAPA was to create a class of people who are untouchable. And I get maybe that's more of a political argument. I'll caveat that. But the president said these people cannot be removed by the next president. Can you imagine the outroar of people who have been here working for 4 or 5 years, or whatever else? It creates a sort of protection. It's not citizenship, but it's a quasi-protection status that the president knew when he created this program.
But how would this status differ from any other status that can be revoked if there are certain convictions that?
Right, but what status? A status supported by Congress that I have no problem with. My argument is this status the president did not have the authority to give.
And just to be clear, right, for 2 reasons. 1, the president doesn't have the power to categorically exempt them from deportation, and 2, the president doesn't have the power to give them work authorization. Those are your arguments.
Nutshell, yeah. Okay. Yes, sir?
Isn't the president in sort of a Youngstown Box 1 situation here where Congress has said you have some ability for deferred action and the president's taken that and then Congress has then since funded the INA after that?
Right, so the Youngstown issue is very interesting, right? And I don't think this is Box 1 or Zone of Youngstown, where I don't think there's actually clear congressional support for it. There's no statute authorizing to do this, even OLC recognizes. You need to look to congressional policy, which is broader. And the way I read congressional policy, my friend Steve disagrees, is that there has not been authorization. Perhaps we're in a Zone 2. I actually think we go a little bit down because Congress has actually voted resolutions to oppose this. Now, Steve's right. Congress has voted to fund DHS. We had a near shutdown last year of the federal government over this, although I'll slightly caveat this by saying that they never actually funded this program. This policy is funded by user fees. So in fact, Congress has absolutely nothing to say about this. So the funding, I don't think, cuts one way or the other. But but the House has passed resolutions saying we disfavor this. And in terms of is that relevant, in Dames and Moore v. Regan, one of the cases that we often study in separation of powers, the fact that the Congress after the fact, the Supreme Court looked to the fact that Congress has not opposed the Iran settlement process was one of the reasons why they upheld it. Here, Congress has been viciously opposed to it subsequent to the action.
So let's just be clear. The thing Congress did not vote to approve was the DREAM Act and not DAPA, right? And so when Josh says Congress opposed this, what Josh means is that Congress opposed a larger bill of which this was.
No, they passed a resolution in opposition to DAPA. The House did.
Right, the House did. So not is the House Congress?
Well, they just have standing now, don't they?
You said you weren't talking about standing.
Yeah.
So Josh's point is that one House of Congress, after the fact, passed a resolution saying they don't like something.
I think that's relevant.
Fine, point me to any
Daines
case.
and Moore v. Regan. There were actually statements of the fact that one member of Congress spoke in favor of it, and that was evidence to support the action.
Right, I'm asking a different question. Point me to one case in the 63 years since Youngstown's been decided where the fact that one House, after the fact, disapproved the action led the court to conclude that we were in category 3.
We don't have
One case.
We don't have many separation of powers cases. We don't have those cases. These are fairly rare cases. But the fact that the
So
support,
0 is your answer.
well, no. But actually, Youngstown itself did. Remember, in Youngstown, after Truman seized the steel mills, the House took no action, and that lack of action was salient. So I think the lack of action is salient.
In Youngstown,
positive action is salient,
Youngstown, President Truman went to Congress
and they did nothing.
and asked them to vote on it, and they did nothing, which
Yes.
the court read against him. Right. President Obama did not go to Congress and say, "What do you think of DAPA?" And then both houses said, "We
He
don't
didn't
like
need
it."
to. The House voted against it, and one House thinks it's sufficient
Oh,
to show.
well, one house. Then that's how the separation of powers works.
This isn't a bright line rule, but in terms of congressional disfavor, I think the one House resolution is salient.
I dissent.
Thank you. Next question in the back.
I think I already mentioned it, but what are the actual criteria for prioritization? Because on one hand, you have felons, the other you might have
CBI? Yeah. He has the memo. I'll let him read it.
Now I have to find it.
Effectively, you prioritize felons, people with different aggravated felonies. Then you have less serious felons. I mean, I don't have any problem with the prioritization.
Sure.
Yeah.
So under the proposed policy, DHS would identify 3 categories of undocumented aliens who would be priorities. The highest priority category would include aliens who pose particularly serious threats to national security, border security, or public safety, including aliens engaged in or suspected of espionage or terrorism, aliens convicted of offenses related to participation in criminal street gangs, aliens convicted of certain felonies, and aliens apprehended at the border while attempting to enter the U.S. unlawfully. The second highest priority would include aliens convicted of multiple or significant misdemeanor offenses, aliens who are apprehended after unlawfully entering the United States who cannot establish that they have been continuously present in the United States since January 1st, 2014, and aliens determined to have significantly abused the visa or visa waiver programs. The third priority category would include other aliens who have been issued a final order of removal on or after January 1st, 2014.
So there seems to be no indication of professionals who have actually done really well. It's more about comparing.
Are you talking about like people with certain skills or qualifications, or like H-1B type?
Visas, but maybe their visa expired and they're still here. Would they be subject to deportation?
So, I think this underscores my whole point, which is they would be subject to deportation, and the executive branch would never in a million years seek to deport them.
Josh, you focused on the fact that there were very few denials or revocations of his status. What percentage of those would you deem necessary? If there was a higher percent, let's say 5% denied or revoked, would that be enough to make this a legal program?
Right. So I didn't get into this, but antecedent to the very, very low denial rate was the actual process that DHS structured, which effectively amounts to a rubber stamp. Traditionally, agents were allowed to use certain types of discretion, one or the other. Here, there was a very formulaic checklist. There was actually a series of checkboxes that had to check off to see if the person met certain conditions. There really wasn't discretion. And one aspect we didn't get too much was discretion, and this is what they said in Arizona v. US. The discretion of the executive branch on a case-by-case basis is instrumental to decide if the president's actually engaging in his authority. Here, this was set by the secretary to basically say anyone who applies gets it, and I think that goes beyond the scope of discretion. Do I have an exact number? I don't. I don't pretend this is a bright line rule. Separation of powers cases seldom have a numerical cutoff.
Anyone who applies who is eligible.
Yes. Okay. Yes. Other questions? Yes.
So this is supposed to, people lose their status under this law if they commit a felony.
Or various other things. If they misrepresented things in their application, etc.
Dishonesty, stuff like that.
Do they anticipate that felonies or people who are probably going to commit felonies are actually going to sign up for this?
Well, that was my point, right, about deterrence, right? I am not, there are immigration law experts on our faculty. Some of you probably have spent more time in the immigration system than I have. It has not been my experience that the kind of people most likely to abuse this system are the ones who would volunteer to sign up for it and thereby be tracked by the government.
But then what's the point?
What's the government's point?
Well, if part of the advantage of this is so that if people do commit felonies.
Right. I briefed this issue. This program will be absolutely terrible at identifying felons. Absolutely terrible at identifying felons. Because of course it's not the point. They're trying to get people to stay here. The entire ruse that this is trying to identify felons makes no sense because felons aren't going to sign up. Only people are going to sign up are those who are likely to get it. In fact, that's one of the reasons why the approval rate is indeed so high.
So let me go back to let me go back to where I started. There are 11 million people in this country who are subject to deportation. All right, an overwhelming majority of those folks are law-abiding individuals who have never committed a crime in their lives, including, right, it is not a crime to overstay a visa, right? It is not a crime to be in this country out of status by itself, right? The purpose of this program is to give those folks who are law-abiding, who contribute to society, and who have, value to the United States, some moments pause. Right, the ability to not have to look over their shoulder on their way to and from work every day. If they get into a car accident, the ability to go to the hospital, right? The ability to actually not live in fear of the government, but to actually participate in the community. Now, we may disagree with the policy wisdom of those choices. That's perfectly fine. All I've been trying to suggest is that that is not in any way inconsistent with the discretion Congress has vested in the executive branch historically to figure out how to prioritize who should and who should not be focuses of deportation efforts.
I guess I wonder why, Steve, you gave up on Dreamers' parents, and you sort of seem to support the memo from the president on them. Couldn't you could even, I think, extend the same argument you've been making to them, and it wouldn't raise any problem with larger discretion.
So, Josh mentioned at the top that he's making a legal argument contra his policy views. With regard to the Dreamers, that I feel the same way, right? That I actually think the policy arguments are very strong in favor of treating them similarly. My concern is that you need a stopping point, right?
That's a stopping point, yes.
Right, right, Josh and I both agreed about the IRS example, right? That there has to be some point past which the agency is stretching the limits of its discretion. And I just worry that as the Olson memo, I think, fairly powerfully argues, there's a missing logical connection once you get to parents of Dreamers, that's to say parents of folks who aren't of themselves on a path to citizenship.
So doesn't the Dreamers, the fact that we have it, is a sign that they are in this odd status, that they have some of that connection, and therefore you do the same thing with
that connection was created by executive policy. I'm actually defending Steve here. That was created by executive policy itself. So it's like building one layer of executive policy on top of another.
Right. Another way to put that is, if Congress had passed the DREAM Act, then I think some kind of DAPA-like program for Dreamers' parents would be perfectly defensible for the same reasons why DAPA itself is defensible. Right. I just worry that if this is permissible, then I don't know where you draw the line going backwards.
So my good friend Steve said we do need a stopping point. We do need a slippery slope. And if I've done nothing else today, it's convincing you that there is a scope, there is a limit on the scope of executive discretion, whether it's where I am or where Steve is. We had a nice hour-long debate, but there is.
Does anyone think that's not true?
Yeah, there is. No, indeed, many immigration law professors said that there is no limit. In fact, Hiroshi Motomura, among others, have said as long as the president is in the ballpark, he can basically grant deferred action.
The ballpark's a limit. Have you ever seen Giancarlo Stanton hit? The ballpark is a limit.
Motomura, among others, said there's basically no limit. It's basically on the president's own decision what's good or not.
But let's be clear, right? So I think it's very, I defer to the administrative law experts in the room, but it seems to me that Congress has a wide range of choices in deciding just how much discretion it wants to confer upon individual agencies to deal with individual programs. So Josh is adamant that we have to look at individual immigrants on a case-by-case basis. I want to suggest we have to look at individual statutes and agencies on a case-by-case basis. And it has historically been Congress's approach to leave most of this to the executive branch. And listen, if Josh is so worried about this, Congress can pass a statute.
Would he comply with that statute,
or
would he just disregard that one?
What statute is President Obama disregarding?
The INA.
What provision of the INA is he disregarding?
There is no INA provision about deferred action. We've gone through this 100 times. I don't think he has authority to do what he's doing here. Sigh. Questions? Other questions? Second or anyone? First question in the back.
How do you foresee this holding out with the new president on the other side?
Is it okay? So that's a really interesting question, right? So, President Ted Cruz walks from day one and says, "I'm going to rescind the DAPA memorandum. I will rescind the DAPA memorandums. Y'all subject to deportation now." Is there anything to stop that?
Yes, the deportation capabilities of the Department of Homeland
I didn't say
Security.
deport. I said you're subject to deportation. Your work authorization is hereby rescinded. You're subject to deportation. That's why I think that, and this is more of a policy argument, that's one of the dangers of doing this sort of thing.
Can you answer the question? Is there anything to stop it?
No, absolutely not. Right. No, absolutely not. I think any president could rescind this. In fact, candidate Hillary Clinton said she will continue this. Maybe said she'll expand it. I haven't gotten a clear answer on that.
And Bernie Sanders said he'd kill everybody.
Well, Bernie Sanders is not very big in immigration either. It's an interesting aspect of the socialists. They don't like they like protectionism. Yeah, but yeah, absolutely nothing. The better question is, what does the Supreme Court do about this? So the Fifth Circuit is currently considering. The Fifth Circuit already granted what's called a stay. They put the program on hold. The injunction is still in effect. So that's still in effect, but the Fifth Circuit has to rule on it. Any day now we can get a decision. And we'll have a cert petition probably the next few months. The better question is, what happens if this case is argued so late that it gets kicked until the next year, and it's not decided until there's a new president in office? Will that SG even defend this policy? That's an even better question. President Obama, his clock is ticking. I'm sure you have some of your clocks are ticking down. Depending how long the Fifth Circuit takes to rule on this, we may not get a decision on the Constitution of DAPA until 2016.
Wait, we're not going to get a decision on the Constitutionality of DAPA anyway. So let's be clear. The district court injunction to which Josh is referring did not in fact hold that DAPA violates the Take Care Clause. The district court injunction holds that the manner in which DAPA was promulgated violates the APA, right? A technical violation of the procedural mechanics for implementing federal policy.
Will there be enough time for notice and comment?
We could have a fight about the merits of the APA claim, but how many of you guys have read a Supreme Court case where the court went out of its way to reach a constitutional question when the lower courts were only considering a technical violation of the APA? Anyone? Right, so the courts are not going to resolve the constitutional question. The courts are going to fight over the APA, and this is going to ultimately be resolved, I think, by the voters in November of 2016.
I think I agree with that. My brief will be cited by no one, but I will write it, I promise. Maybe one more question?
Paul, you had another one?
Yeah, Professor Blackman, you said one of the problems with the scope of the president's discretion. You mentioned President Bush gave a 3-month discretion. That there's no problem with that. So what if President Obama said this is a 5-year renewal or a 10-year renewal?
Well, there are 3-year renewals. It's basically a 3-year fixed period, or 2 years.
What's the problem then between?
Because what happens on the other side of that 3-year period, right? With the case they gave with President Bush and Katrina, schools are open. You can go enroll somewhere else. There's a logical stopping point. Here, there's no statute. There's no pot of gold waiting under the rainbow, right? There's nothing waiting for
So that's actually not true, right? The hope is that sometime in the near future, Congress will exercise some degree of institutional responsibility.
But doesn't that prove Congress hasn't given that benefit? It has to be something has to happen. There's no yes, you're hoping and praying on wishes and lollipops that something happens, but that's not what's in the
I'm hoping and praying on wishes and lollipops that Congress does more than just temporary deferral of status, and that Congress finally actually realizes that it's up to it and not to leave it to the president by himself to take meaningful, comprehensive action toward immigration reform. This would happen in the 1950s, this would happen in the 1960s, it happened in the 1980s, right? And so my point is not that the president can't act without Congress. My point is that the president can only do so much without Congress. And that if we really want a meaningful, long-term, stable solution, that's up to Congress. Is it so preposterous for the president to say, until that happens, I'm going to do everything I can?
Yes. So on that one-word note, I thank you all for your attention. I thank the Federalist side. I thank my good friend Steve. Thanks so much.
All right, go vote.
Go vote.